Thank you for joining us for today's webinar, an update on the claims process for textbook and academic authors in Bartz v. Anthropic. Brenda Ulrich, an attorney with Archstone Law and a TA board member, will be sharing an update on how your unique ID will help you when filing claims, as well as other updates on the claims process and TA's recommendations for textbook and academic authors whose works are included in the settlement. Brenda practices publishing and intellectual property law at Archstone Law Group, where she is a partner. She represents many textbook authors in drafting and negotiating publishing, licensing, and collaboration agreements, and in resolving publishing disputes. She also advises colleges and universities on the development and implementation of intellectual property policies, navigating copyright questions related to teaching and scholarship, and managing and defending trademark portfolios. My name is Kim Pawlak, and I'm TA's Executive Director, and I will be assisting during the webinar. And thank you so much for joining us, Brenda, and thank you all. Brenda, you're on mute. I'm
Yep.
sorry.
Sorry. Kim, do you want to go up one slide? Because we had a little disclaimer.
Yes. So
Which
we
is
have
important to note is that TAA is not representing any individual authors in this case. We're trying to help our members and the general textbook and academic community navigate this process. But each author, has their own specific claims, their own specific contracts. I mean, same for the publishers. So this is just to try to help people kind of navigate the process. But for any specific legal advice that you need, you would need to speak with your own attorney. And with that, I think we can put away the legalese and jump right into it. I do want to note that Kim and I did a presentation on this case back in October, early October, another webinar, which provides a lot more context and background. So I'm going to try not to repeat too much of what's in that webinar. So if you missed it, it is available on demand. I would suggest go back. That just tells you more generally about various parts of the case and where we were at that point. But just to give you kind of a 30-second overview about what this case is all about. This was a class action lawsuit brought by authors against Anthropic, which is a company focused on building AI large learning language models such as Claude or ChatGPT. To train its models, it used hundreds of thousands of copyrighted works. The authors whose works were included in this sued for infringement. The judge in that case found that Anthropic's use of what it called legally obtained works was fair use under the Copyright Act and therefore not infringement. So what this settlement is about is that the plaintiffs claim that Anthropic infringed protected copyrights by downloading books from two data sets, one called Library Genesis, or LibGen for short, and one called Pirate Library Mirror, or PLME, which you'll see referenced on the website for the case. Anthropic denied these claims. The court didn't ultimately decide who was right, and instead both sides agreed to settle the case to avoid more litigation. And the settlement in this case is where this $1.5 billion settlement amount comes from. So where we are now is in the claims settlement claims process, which is the process of people who have a claim for infringement to file a claim so they can be part of the settlement group that gets paid out of this $1.5 billion settlement. I do want to note, there are about 500,000 works, copyrighted works, that were in this database, or these two databases of infringed works. Only people, please mute if you are not speaking, thank you. Only people whose works were in those two databases have a claim. You can't add in now to try to add, if your book was not in that group. It's not available to all authors. And if you, I've had people ask me, authors ask, can they add now or why they're not there? If you've gone to the website, and I suggest you do this, it's the anthropiccopyrightsettlement.com website, and Kim will put that in the chat. There is on that website something called the Works List Lookup tab, where you can enter your name and find out if any of your books are in that class. If you look up your names or your titles and you don't find them there, then you are not part of that class. So TAA also provides a link to this tab from its website. So that's sort of the first thing to do, is to even find out if you're an author in this class. Because if you're not, you can log off right now and get this hour back because you don't have a claim. So what is the big news since the October webinar? So the main thing that has happened, and the reason we are having this webinar today, is that notices have gone out to all the potential claimants identified by the settlement administrators. So these notices are going out via both regular mail and email. So I want to actually show you, I have a bunch of visual aids today because this is very easily going to get mixed in with your junk mail and you won't even realize what it is. So if you have received an envelope that looks like this, let me get it in focus. And it's not working. Anyway, it says Anthropic copyright settlement in the upper left-hand corner, care of JND Legal Administration. And Kim and I can get visuals of these put in. And it says on the front, important class action notice authorized by Senior District Judge William Alsup. So it's one of these with a window here. There's the court and there's the notice there. If you get one of these, don't throw it out. It's not junk mail. If you get several of them, they are not duplicates. So don't throw out if you've got 6 of them and you think, well, these must just be accidental copies. No. And I'm going to explain a little more later. What do you do if you already threw it out? Good question. We'll get to that in a bit. They also are going out via email. So check your email if you have something from an email called info@anthropiccopyrightsettlement.com. And it will say on it, the subject line will be court notice, Anthropic copyright class action. There's a good chance this ended up in your spam, so I would look for it there as well. If you deleted it, maybe you can get it out of your deleted. In either case, whether you got notice by email or by regular mail, what you are looking for, first of all, is your unique ID. Now, in the mailed versions that showed up in your mailbox, there's a cover email. I'm so sorry, this is fuzzy. I'm not used to doing this. But anyway, if your address was right here, the normal address, up above to the right, it says unique ID. And that's where there is a number. It's very small font and it's easy to miss it if you didn't see it or you didn't. I've had people email me everything else that was in the envelope and say, what do I do with this? And they didn't realize this page was actually very important because it has your unique ID on it. And the unique ID doesn't show up anywhere else in the packet. So this is where you go. Your unique ID is in the upper right, and it's again right by your address. So you can look there. If you got the email, you look into about, there's a notice of what the lawsuit's about, things you can do. And then about a third of the way down into the email, it says your unique ID in a box, and it has the number there. So those are the 2 ways you can get your unique IDs. And I'm going to talk a little more about what you do with those unique IDs. But one important thing, because there's been a lot of confusion on this, is if you received more than one unique ID, why? And a lot of people are asking, well, I assume I get one unique ID for each work, for each of my books. No, that is not the case. It happens that my father is a member of this class, so I've been able to sort of navigate this from the perspective of an author. Between he and my mother, they received 3 notices. Each of them has a different unique ID on it. One of those mapped to 2 works, one of which was a mistake and one of which was his work. The second mapped to 8 of his works. So the best reason I've been able to figure out why authors are getting multiple notices is that if there's any variation, say in the spelling of the author's name, if a middle initial is included or any variations like that, the system applies a unique ID to each of those. So unfortunately, there's not a one-to-one matchup of unique IDs to works, nor is there just one unique ID for author. For whatever reason with this system, sometimes you get multiple unique IDs and there might be overlaps between which works are referred to by which IDs. And don't shoot the messenger. I have no part in this process. We're just trying to understand it just like you are. But that's sort of one of the quirks and frustrations of this, that there's these multiple IDs. And I do want to say we have 2 of the class counsel on this call, so if they have any insights to add on these things, please speak up, because we're all trying to figure this out.
Sure. Thank you, Brenda, for that. And to clarify, some of the reason why some folks are getting multiple unique IDs is because the settlement administrator may have multiple email addresses or multiple points of contact for you. So that does, if you get more than one notice in the mail or by email, it doesn't mean that there's something wrong per se, or that one unique ID is not right and the others are correct. If you use one of those unique IDs, it should populate all of the works that you have that are related to your name. And for some reason, if that's not the case, you can contact the settlement administrator and they will help you file your claim. So just wanted to, I understand that's a little bit confusing, that some of you may have received more than one notice in the mail or by email, but please don't think it's some sort of problem with your claim. It's just a logistical issue where the court directed us to provide notice in multiple ways, by mail and by email. And so it just may be the case that they have multiple forms of contact for you.
Yeah, so the hope is that it's overkill rather than
Exactly.
an attempt to catch everything.
Exactly.
But it does make it more cumbersome. And as I said, I found one ID only had one of the actual works tied to it, so I wasn't depending on one ID to make sure we caught everything. But I'm going to talk a little later about how to try to make sure you're capturing all your potential claims.
That's actually helpful feedback for us, Brenda, that we can take
Yeah.
back to the settlement administrator, because that's something I haven't heard yet. So if there's any other issues like that is helpful, that is useful for us to take back, we're happy to do so.
Great. And then the packet, if you get the physical packet, you will also see in it a single blue sheet that is sort of a short list of information about why you are a class member and what you can do now. It has a QR code and the website address and a lot of contact information. And then there's this 24-page packet with much more information about the case. It includes 56 questions and answers, which are the same as the FAQ on their website. I think the number one question is, do I have to read this packet? And, I would say I tried. I did. It has a lot of information about the case. I'm not sure you need to know all of it to be able to proceed. Also, and again, they repeatedly provide you with emails and contact information for people who can help you navigate this process. And the main one is info@anthropiccopyrightsettlement.com, which I know Kim has or will put in this chat. Another email address that is important, especially if you have multiple works in the class, is bulk claim filing at anthropiccopyrightsettlement.com, which is where they can help you if you have multiple works. Because as we'll talk about, once you have a lot of works to claim, it gets more complicated. So, and this is not just for authors, but publishers as well. I'm working with a publisher who has over 300 works in the case. So we are trying to, get help from this bulk claim administrator. I do want to disclose, I have put in a request for assistance with that bulk email address on behalf of my publishing client, but we're in the midst of that process. So I can't tell you how helpful that is or will be, but, we'll keep you posted. So in the notice that you receive, it says sort of, what are my options? And it spells out 4 options. And I'm going to actually share screen here. Okay. Let me know, somebody let me know if you can see that. Learn about your 4 options. Somebody nod if they can see that. Okay, so the 4 options and due dates. So we'll talk about the due dates because they're coming up here first. Is the deadline to file a claim, and we'll talk more about that, is March 30th. I'm not showing. So the 4 options are to file a claim, and we'll talk about how to do that, to opt out of the claim. This means that you choose to exclude yourself and your works from the settlement. And the reason you might want to do this is to preserve your claims if you wanted to bring a separate lawsuit. And then we could discuss more what the opting out means. But note that all works have at least two potential claimants, an author and a publisher. If any one claimant opts out, that opts the whole work out of the settlement. So nobody can make a recovery. So if the author opts out or the publisher drops out, or if there are multiple authors and one of those authors opts out, none of the claimants can recover from the settlement fund. So guidance on how to do the opt-out is in, I think, question 40 in that packet or on the FAQ. Note that if you opt out, and it shows here January 15th as the deadline for doing that, you do have the option to change your mind and opt back in up until March 9th. So there's question 41 in the packet has more about that option. You also have the right to object. Objecting is not the same as opting out. Objecting means you don't want to opt out, but you have issues or disagreements with the settlement. And where we are in the holiday season, and for you Seinfeld fans out there, I view this as like the Festivus moment. This is where you can air your grievances about what you think is wrong with this settlement. Question 44 has more guidance on how to tell the court if you don't like the settlement and why. The last option, of course, is to do nothing. And in this case, you may still be eligible for payment if another claimant for your work mentions you as a potential claimant. And we'll talk a little later about when you need to mention other potential claimants to a work. But question 46 in the packet talks more about that option. Okay, so I'm gonna stop share. So what is the first thing you should do? Is I would say before you even try to file a claim, if you want to go the claims filing route, okay, we've talked about the other three, but let's assume you've decided you've gotten the notice, you want to participate, you're hoping to recover, then you can file a claim. The first thing I would do before is you go to the website, the Anthropic settlement website. Actually, Kim, I don't know if you want to share screen and do this, that might be simpler. But there's a tab at the top that says Works List Lookup. And you can search there by your name, by your title, your publisher, ISBN if you have it. But I would say the reason I would search here first is because once it gives you the results based on your name, you get a lot more information. It will tell you the ISBN and copyright numbers. It will tell you edition numbers of your books that are in there, the full title, any co-authors that are listed with the book, all of the information that they gathered in the database from the Copyright Office and other sources. So when you look up in the Works List Lookup is where the most information is to be gathered about what they have on file for your works. And what I would do is do the search and then print out the results or print to PDF, because you can't, unfortunately, another frustration with this website is there's no way to like set up a user account so you can save things and go back to them. So you can't save anything in that system. So you have to sort of print or save it outside. And I mean, if they could add this, it would be great, because if you could have just a login so you could keep working on your claims and not lose everything you've done, that would be really helpful. But right now, that's not an option. So I would say print out your list and have that sort of for reference when you go to file a claim. Okay, so how to file a claim. The window is open, but it won't close until March 30th, 2026. So I do want to stress that you have time. There's no rush to do this fast, and there's no payouts happening until August. And all the claims will be treated the same regardless of when they came in. So there's no like first to file is the first to recover. It's not like that. So there's no benefit for going fastest. The goal is to get it right. So if you go to the home page, Kim, if you would, yep. And then scroll down, all the way down, keep going. Here are the dates again of what you can do. But go to the bottom and it says, if you would like to file a claim, please use the online claim form. And before you go there, just note below it is the option to opt out. That's where that lies. Yeah, but let's go to the online claim form. So that's brings you to this page. Now, again, you need to scroll down because for some reason it's all the way down. And then you click on the File a Claim tab. Okay, and this is where that unique ID comes in. And this is why we didn't want you to throw that out. So if you have your unique ID, you can fill it in here. And I'm going to just 1 second, because oh, why don't you, if you want to speak a second, that'd be great, because I'm going to actually get to the login page. Yella, do you want to?
If you don't have a unique ID, you can click the button, I don't have a unique ID, and it will take you to the claim form as well.
Sorry, was there a question for me? I was answering questions in the chat and had a hard time doing both, answering questions and listening. Brenda, did you have a question for me as well?
No, I saw you were answering the chat, and I didn't know if you had something you wanted to add.
Not at this moment, but
Okay.
happy to listen more closely. Sorry about that.
Okay. All right. And so Kim, actually, if you can stop sharing, I will share, because I want to get to the next page with a unique ID. So I'm going to share my screen again. All right. If you cannot see this, please tell me. But I'm going to, so what happens now is you enter a unique ID, which I've done, but what it takes you to is another form you have to fill out. So I don't know why, if you received a notice at your house, why you have to put in all your address information again, but you do. So everything that's starred here, you need to fill in claimant name, address, phone number, what kind of claimant you are, and that you click that you're not a director of Anthropic or part of the court unless you are. And then you fill that in. So this is just a page I wanted to alert you to, because I think people thought once they put in their unique ID, they would get their list of works, but there's this added form you have to fill out. And so once you fill that in,
I will just say that I think that probably is that needing to fill this in is probably related to fraud issues. So we just want to make sure that troublesome third parties are not, attempting to fill in claim forms for authors.
got it. Okay. So there you go. Now, also keep in mind, once you enter your unique ID, it doesn't show up on any subsequent screens. So, which is, for me, I got a little confusing because I would be trying to fill in multiple forms with the different IDs that we had, but then you can kind of lose track of which ID went with which list of works that showed up. So I just think it's good to have your unique ID nearby in case. The other thing is, if you pause for a while on this website, it boots you out. And as I told you before, you can't save your work. So having the unique ID easy to cut and paste in will just speed up the process for you. So once you fill out this page, you then advance to the page that should show you all the works connected to your unique ID. And because of the sort of inconsistencies between the unique IDs, well, there's two ways. One is you fill them all in. You go through this process with each of your unique IDs, or you go to the claims page, you see what's on there, and then you use your printout from your lookup page to add in more works. You can do that on the claim form. You can add in additional works if you know the titles and the information that was listed on the who is lookup. So I'm stopping sharing there. I fear this is where it gets sort of confusing. And I can't really show you more of the process without revealing individuals' information, which I don't want to do. But yeah, that's when you fill in the info. So when you get past that login page, that's when it starts to show you each of your works, and you'll have to add in some information. So it will show you the title of the work, but then you add your author name, the publisher name. And this is also the place where you can fix mistakes, because a lot of authors have said they've seen mistakes with titles, with their names, with that's the sort of thing. This is now a form that is active that you can change that information to make it correct. It will also ask if you're the sole owner of the reproduction rights. And there's a link to an FAQ explaining what they mean by that question. If you answer no, it will take you to another form where you are asked to fill in information you have about other possible rights holders, like other authors, co-authors, or publishers, and any contact information you have for them. So this is where, if you got it and, your co-author doesn't know about it, or perhaps your co-author is deceased and it's their widow or widower who is entitled, that's where you can fill in their information. And this is how someone could potentially become a claimant, even if they don't fill in the form themselves. Because if somebody else mentions them as a co-author, then they become eligible as part of the class. And I think that is also where the publishers are obligated to fill in the author names as potential claimants. But maybe one of the class lawyers can confirm that for me, right? That the publisher has to fill in the author name.
Yeah, so anyone who is filling out a claim form needs to list the other claim class members or rights holders to that particular work. So that's right. Publishers have to do that too if they're a class member.
Okay, and they have to put in the author name because
Oh, absolutely, yes.
Okay.
Yeah.
Yep. Okay.
But just to reiterate the point that I think that we made in the last webinar, everyone should still submit a claim.
Yeah.
Because you don't want to rely on other class members to submit the claim and name you as a class member when you just don't want to depend on somebody else to have the chance that you might lose out on being able to participate in the settlement. So absolutely fill out your own claim, even if you know that your publisher is going to fill one out too.
Yeah. Yeah, no, absolutely. And do right by your co-authors as well. I mean, if they were authors on the book, they should also be listed. There is also going to be an option on this page. It's going to ask if it is an education work. The definition that has been provided as to what is an education work is as follows. And this is listed in, I forget which question, but it's listed out in that packet. It says, education works are works published by education publishers. Education publishers specialize in creating and publishing works, including but not limited to textbooks for the instruction of students and professionals, which are distributed for and through educational and professional markets. So the shorthand of that is that education works means textbooks, as opposed to trade books or academic works, which are works published like by university press authors, but which are not in the textbook arena. If you are not sure, I think you give it your best guess, that's what I would say. On balance, if you don't know for sure that your book is a textbook, then you should say no. It is how I would go through that. So you should go through this process for each work on the list. If you see a work that is definitely a mistake, if you're a biology professor and you see something on there for economics, there's some snafu in the system that because of an author name or something got mixed in with yours. You can delete those so they don't become part of your claim. Okay, if you say that it's an educational work, there will be an additional form to fill out. That is because, backing up a bit, the way the settlement was structured is that for any non-educational works, meaning trade books, academic books, anything outside of the textbook arena, the publishers and authors negotiated a 50-50 default split of the settlement proceeds. So remember, each work that's in the settlement group is entitled to payment out of that claim. And if there's more than one claimant for a work, that money for that work gets split out between the claimants. Most of the time, that's publisher and author. Sometimes there are more than one author. So in order to simplify this whole process, the party or the sort of representatives of authors and publishers negotiated that for trade books and academic works, they would split these claims 50-50. That would be a default. And that way it just is resolved as soon as the claim is filed. Everybody gets, they split that, whatever that amount is, 50-50. educational works were not included in that default 50-50 split. The reason for this, according to number 27 in the FAQ, is, quote, contracts for education works are sufficiently diverse that a default option could be confusing for authors and publishers. I will refrain from commenting on that statement. However, for this reason, each educational work claim will have to be assessed as to how to split the money between authors and publishers based on the terms of their contracts. For that reason, it then requests that you provide supporting documentation if you have it. So if you have a copy of your publishing contract, you can upload it here, because that's what the settlement administrator will use to try to figure out how to split the money between you and your publisher. But if you don't have your contract or can't really put your hands on it, don't worry, you can skip that step, because I believe the publishers were all required to provide copies of publishing contracts. So once you go past that step, the next page says, is titled Resolving Any Disputes, and explains what the process will be for any disputed claims, which by default includes all of the educational claims, but it also includes any other claims for which any of the claimants didn't pick the 50-50 default split. So that's sort of the whole universe of claims that don't fall into the 50-50 default get thrown into this other process in which this claims administrator looks at the contracts and tries to figure out the fair split based on that. There had been, and maybe yeah, you can weigh in on this. There was before, in the first version I saw before the unique IDs, that you would state how much you thought you were entitled to, but I did not see that option when I went through this process with the unique ID.
Okay, that's interesting. I didn't realize that changed. We can take that back to the settlement administrator. You should be able to um, you should be able to either select the default or explain what you think the split should be in your claim form. If that's not possible, I would encourage authors to email the settlement administrator. If there's a way to make it so in the claim form, please note it in the claim form, of course. But if it's difficult to do that, please email the settlement administrator, let them know that that is your wish, that there's a particular split that you would like to see effectuated. I also want to back up a minute and say I apologize. I have not formally introduced myself. My name is Jaleh Dafa. I'm a partner at Leaf, Cabraser, Hyman, and Bernstein. We're a law firm in San Francisco. We do only class actions on behalf of plaintiffs. I was one of the partners involved in this litigation. I also attended the webinar last time. I'm happy to be back. As you probably saw, I've been hot in the chat answering questions and so anyway, I'm happy to be here and happy to keep answering questions. And I'll let my co-counsel Samir introduce himself as well.
Hi, hi everyone. I'm Samir Doshi from the Sussman Godfrey firm, which was one of the co-lead counsel in the Anthropic litigation. I've also been answering some questions in the chat. Thank you all for taking the time to be here today and to learn about your options under the settlement, and keep the questions coming.
Okay.
I've got a question. Does that mean that they can no longer use our material, or now do they have access to that material for their company?
It's a great question. Samir, do you want to take that one or do you want me to take it?
Sure. So under the terms of the settlement, a few different things have happened. So first, subject to some legal preservation obligations, Anthropic is required to destroy all copies of the Pirate Library Mirror and Library Genesis downloaded books that it downloaded. And those are the works that are at issue in this case and that are on the works list. Anthropic is also required to make a certification that none of the works on the works list were used to develop its commercial model. So those are models like Claude that you might see online. So those are the two kind of key provisions with respect to the use of the unlawfully downloaded works.
So how do we check for that? How do we check that our material is not? I mean, they've got it. So they don't have to say what the source is. All they have to do is have AI rewrite it.
So I guess a few thoughts to that. So first, the settlement does not release any claims based on the output of Claude or the AI works, right? So so on your comment about they can just rewrite it using the AI, it does not release any output-based claims, whether in the past or in the future. And B, the other answer is that they're under court order at the risk of sanctions and a lot of other nasty consequences if, despite promising to destroy the works subject to legal preservation obligations, they do not do so.
Where can we check their website to see what, what materials are covering art material?
The way to find out what materials are covered by the settlement is actually to use the works lookup list on the Anthropic copyright settlement website. There's not a standalone provision on the Anthropic website, as far as I know, that covers that information.
What's the name of their AI machine?
Well, they have a bunch of different models. The one that's most popular currently is called Claude, CLAUDE.
So, I'm gonna just, I'm close to wrapping up here, and I know we have a lot more questions. Yeah, so Jala's gonna check on this, explaining what you think you're entitled to on the split, if you're not opting for the default, or if that's not available to you. The next page is where you elect for the kind of how you want the payment to be made to you. This is very straightforward. ACH, Zelle, check, or wire. It will then provide you a summary of what you've put in, which you can review, make sure everything is accurate. You certify it and electronically submit, sign your name and submit the claim. I did have a couple of sort of wrap up thoughts. I've tried, unfortunately, it's hard to show you everything without showing you specific author information, and I protect authors' confidential information. But just generally, as I said, TAA is not providing legal advice to individual authors. We're just trying to help people navigate this process. We do advise you to look at your contract if you have it, as there may well be important information there that affects your claims in terms of what rights you granted to your publisher. This whole case is based on reproduction claims, and some publishing contracts, you're only granting them certain rights, but not a reproduction right. So that's sort of one area to look into. Other parts of contracts might say how different kinds of monies are split between author and publisher. And that also can give guidance on what you would be entitled to. That's more likely to come up a little later in this claims administration process. That is going to, which is also explained in the packet. That's sort of a two-step process. There's a general claims administrator whose job is to try to resolve these disputed claims. If the parties can't come to agreement with that, it sort of can get appealed to something called a special master, who's sort of like a final judge on these things and is himself a mediator and is going to try to resolve disputed claims. So I think the main thing now to keep in mind are the deadlines that are coming up. TAA will continue to provide more guidance as we learn about it and as we are able to. Remember, you don't need to submit your claim until I think March 9th or March 30th?
I believe it's the end of March.
March
Yeah, the end of
30th,
March
2026
30th.
is the claim deadline.
That's the claim deadline.
Makes sense.
And if you opt out and decide you want to opt back in, that deadline is March 9th.
Yes,
Well,
so
how do you determine the amount of your claim?
So if you're in the default group, and you and the publisher opt for the default, then the split will be, they don't know the exact amount that each work will get because it kind of depends on how many people file claims. I think the working likely amount is about $3,000 per work. Is that still accurate?
That's right.
What's the total amount and what are the total authors?
So it all depends. That's the answer. It depends on how many books you have on the works list. Depends on how many rights holders claim for each work. So if you obviously if your amount changes if you have fewer rights holders per work, you're going to have more that is directly sent to you if you have, one other author versus,
Okay, let me make it a little
authors.
bit more clear. What is the total settlement amount and what is the total number of public books, published books? Forget
The
the
total
number of authors.
Total settlement amount in this case is $1.5 billion.
Divided by how many books?
There were 480,000 works on the works list. But
Jeez.
I can tell you that the settlement breaks down to about $3,000 per work.
Anybody know what 1.5 billion is divided by 480,000? Can somebody post that, please?
It'll be a little higher than $3,000
It's about
per work.
3,000. That's how they get the 3,000.
That's right.
Except that fees come out of that 1.5 billion, right?
Yes, fees and expenses will come out. The 1.5 billion divided per works, again, depends on how many works are actually claimed. And then when you claim a work, it depends on how many co-claimants with bona fide claims there are and what the splits are. But the easiest way to conceptualize it is at a high level, it's roughly $3,000 per work.
That's right.
And what was the attorney's percentage?
That has not been determined yet. So the attorneys in the case filed an application with the court on December 3rd, which was 1 week from today, requesting 20%. The court has not made a determination on what the award will be. The court will make that determination, or at least consider it, at a fairness hearing that is scheduled for April 23rd, 2026 in San Francisco. You can find details about the timing and location of that hearing on the website. And if there are any changes to the timing of that hearing, that will also be posted on the website as well. You can also find a copy of the request for attorney's fees on the website too. If you go to the important documents page, scroll all the way to the bottom, you will see a form called Plaintiff's Notice of Motion and Motion for Attorney's Fees, Reimbursement of Expenses, and Plaintiff Service Awards. That will allow you to download the full submission that plaintiff made to the court about attorney's fees.
Have other AI companies done this to our books?
There are other lawsuits that have been filed. For example, there's a lawsuit that Sussman Godfrey is also the co-lead counsel, as well as Leif Cabraser, against OpenAI, who runs the ChatGPT. You may have heard of this AI, and that's based in New York. And there are other lawsuits as well. The works at issue here, though, are just about Anthropic and just in the two data sets that Brenda was talking about earlier.
How do we know if ChatGPT downloaded our books?
That's the subject of different court proceedings, and that will come up or not come up in those proceedings.
I see a couple other hands up, so I'd like to be able to let other folks get questions in. Chuck, you've had your hand up for a long time, so I don't know if that's intentional, but you need to
Chuck,
unmute.
you're on mute.
Yeah. Chuck, you're on mute. Yeah.
Okay, how do you know if you've got an ISBN number, but it's for for a book that's yours, but it's the wrong title? So if you got multiple books and 8 of them are the correct ISBN number for the correct title, but you got one ISBN number which is for a different work, but it's not the right title, what do you do?
I would still
When
submit
you-
a claim. I would go ahead and submit a claim. If it's on the works list, I would submit a claim and I would mark in your claim that it's the wrong title, but the ISBN is correct. And the settlement administrator will help you with that. And if there's any dispute down the line, the special master can get involved, and that special master is an attorney with a specialty in IP, and there's no cost to any of the class members to go through that process.
One other quick question. So one of my publishers has already indicated they want a 50-50 split. The other publisher has not answered after repeated questioning. So what do we do? Just go ahead and file and wait and see what happens?
Go ahead and file. What's going to happen is at the end of the process, the settlement administrator is going to put all of the filed claims together for each work. And if there are any disputes related to a particular work, those disputes are going to go to the special master. So if in the end of the process, you and your publisher end up having a disagreement about what the split should be, or whether or not the publisher has any rights to the work, that's exactly what the special master process is set up to handle.
Thank you.
You're
Yeah.
welcome.
One comment I'd just make as a general one, this process is not designed, even though it may feel that way inadvertently, to trip anybody up. So if you're not sure about the percentages, or you're not sure about a title, or you're not sure about the unique ID, we encourage you to contact the settlement administrator, and we encourage you, if you're going to file a claim, to do so with the best available information that you have. And if there are going to be disputes and there are going to be challenges which might arise, we're here, the administrator's here. If we get to it, the special master is here to try to work those things out.
I see Hannah has a hand up too. I'm sorry, Chuck,
Yes.
was that it? Go ahead, sorry.
Hi. Well, I wrote Macmillan. My father has books, but his are academic, so the 50-50 split is clear from what I'm understanding. I have like 7 editions of one text, 8 editions of another, and they've used most of them. And I also have 2 co-authors, although I have the most royalty because I did the writing. So, and then I wrote to Macmillan last week, to the editor, and I said, are you guys doing anything? And they wrote back, the editor wrote back saying, yeah, I've heard from higher ups, and they say we are going to file. They encourage you to file, but they can't help us at all. But I was struck by this sentence that they wrote. Unlike some agreements in the trade publishing sector, our contracts with authors generally do not contain specific clauses that govern the allocation of proceeds from litigation or settlements of this nature. And I know that you said that this relates to reproduction rights, but I'm not sure. So this seems a little bit too open-ended, as per usual when it comes to educational contracts. And it seems like anything would go. Presumably, this has been discussed, and I just wonder why they didn't just decide on a 50-50 split with the education publishers, why they thought that would be any more confusing than an academic book that had 4 co-authors and a publisher, but also what you think they are saying with that. Thank you.
I'm happy to take this, Samir, unless you want
Yeah.
to.
Go for it.
So I'm sorry, I can't tell you exactly what this publisher was thinking with this sentence.
Well,
but what I can say is that first of all, you should submit a claim. You should include in that claim what you believe is the fair split for the works that you have. And to the extent that you have any supporting documentation that you can submit with your claim, please submit that as well. Now, as to why education works were set up slightly different, I think the thinking there was that a lot of the contracts involved with education works are varied, and that it would be better for the class to have the ability to submit their particular context and have a certain split that is specific to their own works.
I see.
So that's why there. But if you have, if you have any further questions and you want to talk after the seminar is over, you're welcome to contact our law firm, Leaf Cabraser, or Samir's law firm, Sussman Godfrey, and we'd be happy to jump on a call with you and provide further guidance.
One quick question. When you have when they've used 6, 7 editions of one book and it's like 14, it's like seems I'm a little tired. I'm not sure I want to, what do I, do I really have to do 14 claims? And
no, you do not. You can only,
No?
you only need to submit one claim,
Oh,
one claim form. That's right. And you can list all of your works in that claim. In fact, the unique
wonderful.
ID, yes, the unique ID, the whole purpose, the way that the unique ID should work, and the whole purpose of it was so that it would pre-populate your claim form with all of your works.
Oh,
And
well,
so,
I got a unique ID from my dad because I actually put that in, but I didn't do myself yet. Does
okay,
that mean if I do it, they will send me a unique
they
ID?
should, when you put in that unique ID number, it should pre-populate your claim form for all of your works.
But
Now,
but I mean, I have one for my dad's works, but I never put in a claim yet for mine. Is it too late to get a unique ID?
no, it's not too late. In fact,
So
you should have received it. If you're a class member, you should have received it in the mail
I
and also
didn't.
by
I
email. Not
didn't.
yet. Okay.
I didn't.
It's possible it didn't arrive yet. It's also
You
possible
mean
that
even if you don't put it a claim, they send it to you?
absolutely. That is the
Oh,
point of direct notice. Yes, everyone who is a class member at this point should have received notice of the settlement in two
I've
ways.
received no
In
notice.
mail, you haven't received an email or
And I have
anything in the
15
mail.
books on there, 15
Okay.
editions.
Okay, I'm sorry to hear that. The good news is that everything's on the website, in terms of all the
I
information
know.
and in terms of all the documents and whatnot. But if you need the unique ID, I would just contact the settlement administrator, and they should be able to send it to you.
Okay.
Yeah.
And I just want to make sure the place where you saw your works listed was on the Bartz v. Anthropic official website. Is that the database you looked at?
Me?
Yeah.
Yes, of course.
Okay. Well, because there was earlier in this case, there was a different database that some people looked at that is not the accurate database, and it led to a
No,
lot
no,
of
I was on
confusion.
the other day.
Okay, great. All right, I think. Chuck, you have another question? I don't see other hands.
No, maybe just another answer. I also have multiple editions, and I can say they're all co-authored books, and each of the authors has received these forms for other authors. So I received forms for 4 different authors,
Oh my gosh.
and other authors received forms for me. And so there's just all kinds of forms going to different places. So you might want to check with your co-authors to see if they got your unique
Gotcha.
ID.
I'm sorry to hear that, Chuck. And that's something that I can also take back to the summit administrator as feedback.
And I just want to clarify, if the works lookup has 6 different editions of your book, that counts as 6 different works. So
Well, I was just
you have-
given a different answer I was just I was told you only need one unique ID and one claim. And you
so there's
list all your
one, she
work.
meant one claim form, but on the form you list each work.
Okay.
And each edition counts as a separate work, which means the total recovery could be a lot higher because it's 6 times 3,000, right? So, yeah. Richard Wolfson, your hand is up. You're muted.
Okay. Yeah, I'm most baffled since I got this information long before this webinar about this question of the education works and how we determine the split. It seems very random, and I really wish it were 50-50 like the other works. But my question is, am I to assume that I'm in an adversarial relationship with my publishers about this, or can I contact my editors and say, what is W.W. Norton or Pearson or whoever it is doing with this lawsuit? How are they recommending we split things? Or should I assume that they are adversarial at this point?
Samir, do you want to take this one, or I'm happy to take it?
Yeah, I mean, it's hard to say, Richard, on an aggregate basis. I think when I think about how we've set up the dispute resolution process, the first step when there is going to be a conflict about how much someone gets versus how much someone other gets is the settlement administrator is going to contact both parties or multiple parties, if there's more than one, inform them that there's this dispute and try to get them, to the extent possible, to work together to reach a mutually acceptable resolution on what the split would be. So our process, assumes or at least hopes for the fact that people will be able to coordinate in a meaningful way. Of course, if that is not possible or it does not work, we also have a special master who the court has appointed itself that can resolve these disputes in what would resemble a more adversarial proceeding.
And I'll just
Okay,
add to
thank
that,
you.
Richard. Yeah, no, of course. And I'll just add to that as a premise that hopefully this is not an adversarial, that you're not feeling like you're in an adversarial position with your publisher. That's certainly not the way that we wanted to structure this process. So hopefully there can be an agreement reached through the settlement process with your publisher. But as Samir just described, we do have structured mechanisms in place to help you reach a resolution in the event that a conflict does arise.
Okay, so there's no harm in my contacting my editors and asking how the publisher is handling this.
That's exactly right.
Good, thank
There's no
you.
harm. Yep.
Lynn Wilson asked a question in the chat. If we receive notice for another author, how do we get it to them? And how do we know if anyone received the notice for our work? That is a great question, and it's one that's best directed in the first instance to the settlement administrator. So I would reach out to them via email to confirm, whether others got your unique ID, or if you'd like to share information with someone else, what the method is that they'd recommend, because there's always the possibility that that other entity has already gotten the information.
What would we look for in terms of an email address if they wrote to us?
I will put the
Yeah.
I will put the email address that you use to contact them into the chat. I believe it's the same one that they're using to contact class members, but I am not sure.
Yeah,
So I will follow up.
that is the same one.
Great. So that is info@anthropiccopyrightsettlement.com. And that can be found on the bottom of the copyright settlement webpage.
And if you got an email from them, that's the address it came from, and the subject line should read court notice, Anthropic copyright class action. That's the subject line you're looking for.
Barring any other questions, one last point. I know that the FAQs on the website are extensive. There's over 40 of them. Many of them have multiple paragraph long answers. What I will say, notwithstanding that fact, is that the language used on the website was intensely worked on by the court and by the parties to give class members the information that they need. So I would strongly encourage kind of all of you to review your options and to review those FAQs, in the time that you have, because that will really be kind of the best and most comprehensive source of information.
And as I said at the beginning, TAA will continue to update its website with guidance, send out any information that we learn about. If you have tried to get help and it's not working, let us know that too, because that's what TAA does. It advocates for its members, and will continue to do so through this whole process. Kim, I don't know if you have any other thoughts you wanted to share.
Yes, absolutely. If you have any questions, you can reach out to me directly. I'm going to put my contact information in the chat as well. You can email me and you can call me.
And I see Lillian Black asked, is the information on the website different from that published in the Atlantic in early September? Yes, it is different. That's what I was talking about earlier, that's the incorrect database that a lot of people thought they've had works in that turned out not to be in the final official database. And that's why if you only looked at that Atlantic database, you don't have the most accurate information.
Carol, stop the microwave, please.
Oh, sorry, Jay, you're not on mute.
All right.
Yeah. So I just wanted to say too, I wanted to reiterate because I'm getting lots of questions from members as well. And that is go to our Anthropic settlement website. I've dropped that link into the chat. You can also go to the TAA website homepage. And if you just scroll down a little bit, there's a banner image that links, it says latest updates is the button if you want to click on that. And that's all the information that you need on there. It also has links to the official Anthropic settlement website that Samir and Jala, I'm sorry if I'm not pronouncing your names correctly, have been referring to. There's a link to the works list, the claim form, and also TAA's guidance, especially for authors of educational works. We have some guidance for you as you're filing claims. So I do recommend that you go there and review that if you have not already filed claims. And also to say that you can amend your claim. If you've already filed a claim, but you've learned something by listening to our last webinar or this one, you can amend your claim if you would like to do so as well.
I'll just add too that our law firms are available to help in addition to the settlement administrator. So if you're having any issues, please do contact our law firms. We have a team of staff and attorneys here to assist, and it's a pleasure to do so. So thank you for attending today.
Real quick before we sign off, a question for either Kim or our guest speakers. A point of clarification. If we have a book with 3 authors, does each author get his or her own unique ID?
Yes.
Okay.
And then to respond to two other questions in the chat, first from Susan Fawcett, what should we do if our publisher refuses to answer or even acknowledge that they know about the settlement? The answer is that if you have a work on the works list that you'd like to submit a claim form, please complete the claim form to the best of your ability, providing the information that you can in good faith. The next question from Dana Lowy, can we trust that the Anthropic list of works is truly comprehensive and complete? I could say we made significant thousands of hours worth of effort to compile the works list. I will also say, if you have a work that is not on the works list, that means your work is not released. That is to say, you can still bring your own claims. There is no circumstance that we're aware of, or let me phrase it differently, that the release only applies to works on the work list. So if you don't see your work there, your claims against Anthropic are not released. One last question, Frank Carano asked, I've received two different IDs via email. Which do I use? Frank, you can use either of them. Your main response, and they may give you different information. To hedge against that risk, when you complete the claim form, please use the work lookup tool to make sure that you're claiming any and all of the works on the list that you are eligible to claim, even if the unique ID does not populate that work on the claim form. It should, it may not. We're obviously apologetic for that difference, but this is the best way to handle it. I didn't see any other questions, so I'll just say thank you to all of you for your attention and for letting us kind of talk to you about the settlement today.
Thank you.
Thank you for your time.
Yes, thank you everyone for joining us for today's webinar. Thank you, Brenda, for your diligent work and staying abreast of this case and helping us with it. Brenda has been helping us from the beginning, as well as another attorney, David Slarsky, who's not here today on the webinar. And we are working very hard to advocate for textbook and academic authors and to provide you with as much information as we can to make sure that you receive the amount of the settlement that you deserve. So again, my contact information is in the chat. You can also go to the TA website, go to the Contact Us tab. My contact information is there as well, and you can reach out to me with any additional questions. But thank you all so much. And like I said, it was also recorded, and we'll be sending out a link to the recording to everyone once it's ready. So thank you. Have a great rest of your day.